Hello, everyone, and welcome to a very special Unleashed with me, Scarlett Johnson, presented by Moms for Liberty. And you can see that I am joined by my friends and attorneys, Dan Lennington and Cory Brewer. They work with Wisconsin Institute for Law and Liberty. They have been on the front lines of cases that we're going to discuss today. And as we're going to talk about the Supreme Court decision and the big win that we heard today, long anticipated landmark decisions, a definition of Title IX and sex that mean male and female, and that's it. Great. This is great news. I want to celebrate. Now, it's not over yet. Definitely not over yet. There are limitations. This is about the 27 states that they can ban boys from participating in all female athletics. But the scope this is definitely going to help the other 23 states, especially like me, lived in Wisconsin. But I really want to navigate this and get it right. I don't want to tell you something that isn't true or over-exaggerate the win. So that's why I really am grateful that Dan and Cory, that you are able to join us. I have lots of questions. I'm holding my hands. I've been submitted lots of questions, and I know that you guys will give answers as best as you possibly can. So thank you and welcome.
Thanks for having us.
All right. So first of all, I want to say, I'm going to read a direct quote. Schools may maintain women and girls sports for biological females. In other words, schools may determine eligibility for women and girls sports based on biological sex. So that's a huge win. Dan, first, could you set up the two cases that we're talking about, Hecox v. Little and BPJ versus West Virginia? And then just so that for those who haven't been following this as closely, let's set this up.
Yes, so this is about two state laws that prohibit biological boys from participating on girls' teams and vice versa. They are from West Virginia state law and Idaho state law. And those laws went into effect a few years ago, and they prohibited two athletes from participating on girls' teams. The first one is an individual named Becky Pepper Jackson. And Becky Pepper Jackson is a biological male who identifies as female. And he was in high school actually a pretty exceptional athlete as far as girls go. He was a shot putter, won all sorts of accolades, and was the state champion, Virginia Class AAA girls state champion in the shot put. He was the girls state champion in shot put. Lindsay Hecox was more of a middling sort of cross-country runner, but they both sued because they could not be on the girls' team following the Idaho and West Virginia laws. So they sued. Collectively, their case now is called BPJ, because at the time, I think Becky Pepper Jackson was a minor, and he didn't want to be identified, and now his name is public. So BPJ versus West Virginia is what the case is called, and the two cases have been consolidated into one. So from now on, we're not going to call it Hecox. We're going to call it BPJ, as West Virginia versus BPJ.
I just want to interject real fast because in the case, this BPJ, when this case was brought, this individual was, I believe, in middle school, and the ACLU made claims and they were made in court that just an average mediocre athlete. What's the harm? You know, why can't we just let this boy who thinks he's a girl participate? You know, he's no great athlete. But by the time as we all know, it's a long process, a long road to get to the Supreme Court. Just this year, BPJ, as a sophomore, became the champion, the West Virginia state champion in shot put as a sophomore, beating the girls' records pretty badly, I think, and basically bolstering the case of the girls and the parents who said that when you allow this boy into our sport, it's unfair. It's biologically unfair. It's inherently unfair. And so I think it's just important to make that point that when BPJ was younger, the ACLU did try that argument, like, oh, what's the harm? And we hear that a lot, don't we? Like, oh, just let them play. They're not that good. If the girls should just try harder or train harder to beat the boys. You know, they should just stop all their whining. Well, it's pretty hard to do that in something like shot put, where your strength, your muscle, the muscles, all of that, that's going to play in favor of the boys.
Yeah, we'll get into that a little bit later because that's an important legal issue that we can talk about, because there is the defense of by these plaintiffs did say that hey, although we are biological boys, we both took puberty blockers. And we never went through male puberty, and therefore we don't have any advantages. And so that's something we'll talk about at the end of this. But as far as just to set up the legal claims that they brought two claims collectively. The first one was under Title IX, and Title IX says that any educational facility or school or university or K through 12 program that receives federal funds cannot discriminate based on sex. You have to afford equal educational opportunities and cannot deny someone their benefits or their opportunities based on sex. And the second claim was under the U.S. Constitution. So the U.S. Constitution has the 14th Amendment, and it says no state shall deny the equal protection of the laws to any person. And so that originally, of course, in 1868 was designed to provide equality under the law to the freedmen, but over the years throughout the 20th century and culminating with Ruth Bader Ginsburg's decision in United States versus Virginia, the Supreme Court read into the Equal Protection Clause a protection for sex discrimination. That it was not just about race discrimination or national origin discrimination or ethnic discrimination, which is what it was intended to be about. It also included sex discrimination. And so the plaintiffs claim here that because they are treated differently because of their transgender status, they're discriminated based on their sex, and therefore they have this equal protection claim. So those are the two legal claims. One is this statutory claim, the claim under Title IX, which is a federal law, it says no discrimination in education. And the other one is the Constitution. It says the state cannot deny the equal protection of the laws. And so those claims are treated differently, and they have different results. So that's sort of the legal map of what this case is about.
Okay, and Cory, it was Kavanaugh who wrote the majority opinion. And what was the majority opinion about the definition of sex under Title IX?
Yeah, I think there's one line in the majority opinion. I don't have it pulled up right now, but it says something like the term sex in Title IX and its implementing regulations cannot plausibly be understood to mean anything other than biological sex. And I've already seen that page of the opinion, that sentence highlighted and cited all over social media, for example. That's big. And I think too, the opinion starts out with saying there are physical differences between men and women, things like height, weight, strength, speed, endurance, jumping ability, and that these matter in sports. And to me, it's almost hard to believe that we had to have our United States Supreme Court acknowledge A, that sex means biological sex, and B, that males have competitive advantages over females when it comes to sports. But they did, and that's great news. And I also want to go back to one of the very, very first things you said on this podcast was that schools are permitted to separate sports by sex. And I'm seeing a lot on social media in the news about how, okay, there are 27 states with laws that protect girls and women's sports. 23 states don't. We need to work on the other 23 states. Yes, I agree. Girls' sports should be protected across the country. But the opinion also says more than once and very explicitly that schools are permitted to have these policies. So if you're in a state like where we are in Wisconsin, we don't have a law protecting women's sports. There was one passed by the legislature, but vetoed by Governor Evers. School districts can still have these policies, and they pass legal muster under Title IX and the Equal Protection Clause. So one of the things we're working on right now is we've actually drafted a model school board policy that can be used by any school in the country, even if you're in a state that doesn't currently have a state law protecting women's sports. We're updating that right now to be consistent and include legal support from this decision. And I really want to get that word out too, that it's states and schools can protect girls' sports.
I want to say clip it right there, because when I was first writing my social media post today, I put schools, and then I paused for a second and thought, can I say that? Is that because if that's the case, that's a lot bigger than what I'm hearing. So I'm really glad to hear you say that it's true that they put schools, and that was intentional. You think that, and multiple times that schools can decide. So you think that opens the door that schools can operate outside of their state law? Like if you live in Illinois, that schools can have policies that ban biological males from competing with biological females?
That's my read of it. Does Illinois, certain states have certain anti-discrimination state law statutes.
That's what
so
they have.
It could be a battle. However, what the court is saying today, and I had the same thought as you. I had to read it and reread it and say, is this really what it's saying? It says states and schools, if they want to separate sports by sex, that is lawful under Title IX and the Equal Protection Clause of the 14th Amendment. I do think it's important to note that this doesn't mean that states or schools must have separate sports teams. I think that maybe is lost on people that aren't paying as close of attention. This doesn't mean that all girls' sports are now protected, but it means that states and schools can protect girls' sports.
That's a really good point. Dan, your thoughts on this?
Yeah, I don't, as far as the other 23 states, I don't know, maybe you know this, Scarlett, just do some of them have state laws that require transgender kids to be in the opposite sport? I mean, that might trump this, because that would, a state law can be more protective or more restrictive than Title IX. I don't think this is saying if you accept federal money, it's okay to separate by sex. It doesn't say if you do separate by sex, we're going to withdraw federal funds from you. At this point, it doesn't say that. So I would be curious, are there some states that have their particular, like, I don't know, maybe California or even Illinois, maybe it might have a law that says transgender identity is is protected and kids are allowed to be on the sport of their identity.
I think there's non-discrimination policy in place in some of these states that say that there are protections and they could be interpreted that way. But I don't know that where they require. I'm sure that they will try. With this ruling, they might try something like that. But then we have states like Colorado and Washington that have put it to the ballot, where they have been able to utilize the referendum. And in November, the states can decide, the people can decide whether or not to ban biological boys from the sports. And it's going to be up to the people. So it's really good news for them, because if they are successful in Colorado and Washington state, that means that if they get this referendum passed, there aren't the option of these radical leftist groups to challenge it, because they can do that. It's not against the law. It doesn't violate the Equal Protection Clause.
Yeah, I think that's the big takeaway here. And I'm glad, Dan, you kind of expanded upon that caveat, is that we do want to be mindful of any state anti-discrimination laws or other things where there could be a conflict. But what we know from the decision today is that under federal law, such policies are permissible.
Yeah, and I think at least two open threads here for what this means. We'll stay on the Title IX area. One is, like, does it apply outside of segregated sports teams? So this definitely says that, segregated sports teams are okay because the regulations that were passed under the law specifically say separate teams for members of each sex are permitted. Also, separate living facilities are permitted. That's why we have male dorms and female dorms at most normal colleges, right? So you can't separate. So the open question is like, where else is sex separation okay? And the obvious question is bathrooms. I think that locker rooms is probably solved under this, because, and this is the way I sort of think it is, like, if your state says we're only going to have biological girls in the biological girl lacrosse team, then there's no reason for a male to be in that locker room. I mean, if you have already separated the teams, the locker rooms are for the teams, and if you've already separated the teams, then it shouldn't be an issue. So I think locker rooms is kind of solved, because it's just not going to be an issue if you already have segregation. Segregation in bathrooms is certainly a live issue, and that's, we're litigating that right now. So that the question number one is, what areas does this apply to where segregation of the sexes is permitted? And number one is, under that, is probably bathrooms. Then the opposite question is that what if you do live in a state like Illinois or California or Massachusetts, and you are a girl who is being forced to deal with a boy on your team? Do you now have a Title IX claim against your school saying, yeah, I know the Supreme Court said you may separate the sexes, but you decided not to. But the mere fact that the boy is now on my team, I, the girl, I am being discriminated based on sex. I am not enjoying the same level of educational opportunities in programs that the boys have, because the boys, they get to be on their team, and no one is ever worried about some opposite sex coming into their space and messing up with their competition and safety. It's only the girls that have to deal with competition and safety issues. And so if you put a boy on my team, me as the girl, maybe I have my own Title IX claim now, and that's going to be another big category. So those are the two categories I think are open, as where else does this apply? And now, do do girls have the claim to say it's discrimination if you do allow a boy on my team?
So here's Marsha McCleary. She's with Moms for Liberty, Illinois. Illinois has a Human Rights Act law that lets boys who claim to be girls participate in female sports categories. So
Yeah, I think that would be separate litigation because in large part, there's a footnote 1 of this opinion that emphasizes this is more about the may question rather than the must question. May states or schools separate based on sex rather than must they. And I could see something like that playing out in a future, future litigation. I don't know what you think, Dan, but I think then there's the question that you just posed. Does this mean that girls have their own Title IX claim to have teams that don't have boys on their team, or they're not playing against boys? So there's that issue. And then that kind of butts up. It would conflict with if the answer to that is yes, then that would conflict with state law. I know there's a lot of layers to this, but I think it's a question that I don't believe has clearly been answered.
And of course, it is a question that we are posing in our New Richmond case.
Very similar, yes.
So our claim in New Richmond is about boys who are being allowed in the girls' bathroom. And part of our claim is we're saying that the girls are being discriminated because of their sex, because they are being forced to share this disproportionate burden of dealing with privacy violations and safety feelings of being unsafe, because the administration is letting boys into their space, but boys don't have the same issue. And so boys are not having to get tardies, not having to search all over the school for a single stall bathroom. It is a burden uniquely placed on girls. And we're saying that under Title IX, that is sex discrimination. That is discrimination based on sex. Your failure to segregate the sexes is a sex discrimination under Title IX. So that's the opposite side of this coin, and that's one we're pursuing that claim, and I think there's probably others who are doing that too.
And I'll just add to that briefly. So we touched earlier on how the law and implementing regulations talk about discrimination on the basis of sex. And today the United States Supreme Court that said, we don't believe that could be plausibly interpreted to mean anything other than biological sex. They talk about how those regulations have been in place since, they were promulgated contemporaneously or shortly after the Title IX law, and they've remained in place since then, and how they explicitly address athletics in those regulations. Well, guess what? They explicitly address having a separate toilet, locker room, and shower facilities on the basis of sex as well. So that wasn't addressed. The bathroom issue wasn't directly addressed in this girls' sports case, but I believe that the logic flows directly from it. It's very similar reasoning. And like Dan said, we're litigating a very similar issue right now.
And when it comes to the sports issue, it's very important, but not all girls are playing sports. Not all girls are competing at the collegiate level or at the high school level, but all girls are using the bathroom. They're using the bathrooms, and all girls are required to take gym. That's part of state statute. And oftentimes there are certain, there could be a swim session. There could be some sort of activity happening in gym where the girls are getting very sweaty or wet, and then they're going to need to take a shower. And so the biggest thing that we see, the complaints we see all the time, are about boys that are allowed into the girls' bathrooms. And sometimes even the other way, that there are biological girls that are using the spaces for boys. And this is a big issue. There are a lot more claims and a lot more complaints that I field from parents and students that don't want to come forward than what we talk about on social media. It's a much bigger issue than I think people realize. It's becoming a bigger issue, and it's it's kind of the main the main thing that I am dealing with all the time. I feel like at least every week there's another family saying there's a boy in my daughter's bathroom, or there's a girl using my son's bathroom. So this is a big issue.
Yeah, I also hear from parents, Dan, you probably too, probably not as much as you, Scarlett, but there are so many parents that are surprised to learn that this is a policy in their school district and upset that they didn't know about it. They're shocked. Will also has a model policy on separate bathrooms. And one of the things that we've heard, a lot of the opposition we've heard is depending on where you are in the country, something like, and I know this was something in New Richmond, well, we can't do anything about it. State and federal law requires this. And that there's a legal battle going on that we're fighting right now. But I think it's hopefully going to help school board members to be able to point to this United States Supreme Court decision that says sex in Title IX means sex. It means boys and girls. It means men and women. I hope that gives school board members some courage to step up and protect girls' sports and protect girls' spaces.
Yeah, I in many respects, this sports issue is relatively minor. I looked up today who are the transgender athletes that actually participated in the 25-26 year school year, and that media reports identify them. And based on all my searching, I could only find two. One is A.B. Hernandez, who's from Europa Valley, California. That's a biological male who competed in track and field and won all the state track stuff a few weeks ago. And then Becky Pepper Jackson, who's the plaintiff in the case. Most of these issues in sports have gone away because the NCAA changed their rules for this season. It's turned out, as far in a lot of states, obviously 27 states have passed these laws. So it's become a very sort of like a side issue now. I think this issue, though, like that you're identifying, what is happening in schools every single day, that's the big issue. And that's the bathrooms and gym locker rooms rather than sports teams locker rooms, which I was referring to earlier. So yeah, those are going to have to get litigated, and we're happy to bring those Title IX cases. So, but I do think now that we have the Title IX issue should be resolved, because it's the only question under Title IX was, does this law actually allow for sex separation? And the answer is yes, it does allow for sex separation, and it mandates equal treatment based on sex. And they said based on sex means biological sex. So that issue, the plain issue of like, what does the statute mean, is settled. Now the equal protection, the constitutional issue, is not that. The equal protection issue is, did the government give a good enough reason for why they separated by sex? So that's where we get into this issue of, well, are there subcategories of girls or transgender girls who have avoided puberty, and therefore they do not pose a safety issue risk? They do not pose a competitive risk. And if you're excluding those people, does it make sense? Does the government's reason make sense when you're analyzing that small group, that small category of students or athletes? So I think that the equal protection litigation, which puts a burden on the government to justify its policy with reasons, and allows for what we call as applied challenges. So like particular athletes or students bringing particular claims about how it affects them personally. I think that equal protection litigation is likely to probably go on in many more permutations, but it's just this issue of Title IX and sex, and the Supreme Court saying, sex means biological sex, and you can separate people. You just can't discriminate based on sex. And when you treat a transgender kid differently based on their biological sex, you're not discriminating based on their sex. You're upholding Title IX. So my view is I hope it's how the Title IX issue has kind of gone away, at least on this transgender issue. But maybe there's going to be more litigation on the constitutional side.
Cory, I wanted to point, you highlighted that the court's use of one soccer team point. Why does real equal opportunity require sex-separated teams and not one combined team?
Yeah, that was right at the beginning of Justice Kavanaugh's opinion, where he says to provide equal opportunity for female athletes, schools do not merely maintain, for example, one soccer team, one basketball team, one ice hockey team, one lacrosse team that are equally open to female and male athletes. That approach would deny equal opportunity to female athletes because, as all agree, females and males have inherent physical differences relevant to athletic performance. And I apologize. I was laughing or smiling a little bit earlier when Dan said this is maybe not as big of a deal as the other issue, which is true. But as I was reading this morning, I was so excited. I was a college athlete myself. I haven't really shared a whole lot about that because I've been wanting to dive into the legal issues. But just reading this opinion, honestly, it's worth a quick read because there are so many just paragraphs and sections of the opinion where Justice Kavanaugh understands and articulates so well what sports mean to young women. The hours that we put in practicing with your team, working out before and after, at home, watching video. And this is silly, but he even says, a young female athlete might win a tournament or an MVP award or have a home run ball and be able to put that on her bedroom and it stays there forever. And I just texted my mom earlier today, do you still have my awards at home? And sure enough, she sent me a bunch of pictures. So he gets it. And there are so many girls around the country that agree and parents of girls that agree. So it was really nice to see the Supreme Court articulate that from a legal basis as well. I want to just emphasize though on the Title IX issue. Okay, so going back to what Dan said, this is, I think, really important because he had talked about equal protection and has the government done enough to show kind of why it's separating based on sex and how the other side wanted this kind of like a subcategory of girls. And the way the court addressed that was by saying the text of Title IX and the implementing regulations do not say or even hint that schools must allow certain biological males to participate in women and girls sports. Nor do the statute or regulations say that schools must make an exception for those biological males who identify as female and have taken puberty blockers or hormones, which is kind of the subcategory that the plaintiffs were asking for here, saying that they don't have a physical advantage. And the court says, no, we don't have to create a subcategory for some males and based on these very specific characteristics about them. So they say that the statute and regulations don't speak to that issue in a way that would properly be interpreted to require schools to allow biological males to participate in women's and girls' sports. So I think that's very big. Strong language as well.
Yeah, that's really big because that's a common argument made. Well, what if they were taking puberty blockers or what if they were taking hormones, all these hypotheticals, and that they hadn't met that burden to do such a drastic change in the meaning of sex and the protections offered under Title IX and the Equal Protection Clause. I think that's a really big deal, that gender identity is not a protected class under the EPC. I think that's huge. Over the last 6 years, I have attended school board meetings. I've testified in Madison. I have watched committee hearings in person now just recently here in DC. And these arguments are being used consistently by the left. So I really love the fact that they have been wiped out one by one in this Supreme Court opinion. Now, by all means, I don't think that they're going to, take their toys and go home. They're not done fighting, but a lot of the arguments that they use were struck down in this opinion.
Yeah, and they say exactly what you said there, Scarlett, that even if the laws made a transgender or gender identity classification, the Supreme Court has not previously held that this higher level of what's called scrutiny, or what Dan was talking about earlier, this higher level applies to a transgender or gender identity classification. So that I think is really interesting as well. And I don't know if you're planning to get to this later, but we kind of touched on it earlier, and I think a lot of people are missing this. But even the 3 justices that dissented in part, Justice Sotomayor, Justice Kagan, and Justice Jackson, they concurred as to Title IX, actually. They dissented as to the equal protection argument, but they concurred in part of the opinion, which I personally think is a big deal as well, that they agreed with the Title IX aspect and what the statute says.
So yes, that it's a 9-0 decision in some areas and a 6-3 in others. Specifically, what area did they all agree on? My husband actually just asked me this question, and I said, I'm going to ask you guys.
Yes, I just shared something about this. The specific language was that they all agree that the transgender athlete's Title IX claim fails. I will say that the 3 justices that concurred in part, dissented in part, said that they agree on a narrower basis than what the majority relies on. And they disagree. The 3 justices, Sotomayor, Kagan, and Jackson, disagree about the equal protection claim. They think there are unsolved factual questions about that claim and that it should have been sent back down to the lower court to resolve those, but it won't be. So that's kind of an overview of what some of the other justices thought.
Yeah, they say that they have a narrow view of Title IX, but they don't really explain why. I just read it. No. I just read it again, and they agree that these that segregating the teams based on biological sex is not a Title IX violation, and that separating and denying the boy the chance to play on the girls' team is not discrimination based on sex, because sex separation is permitted. So they agree with that. This issue of, and Scarlett, you got this earlier, is maybe the trial court should consider this more. There's all this uncertainty and blah blah blah. That all goes to the issue of do boys who've had their puberty suspended, do they actually have a competitive advantage, or do they pose a safety risk to the girls? And the justices are basically saying, well, there's a lot of conflict in the material, and of course you cite the NCAA and the International Olympic Committee, but there's other studies, and it's just all too confusing, and we'll never really know. We'll never really know unless we have a real trial where we talk about all the evidence, whether these girls in particular are posing a risk to these boys, or posing a risk to these girls. And that's the sort of narrow trial you should have on this issue. But that just muddles it and tries to prevent any decision ever from taking, because every fact situation is going to be different. And the majority said it doesn't really matter. In this level of scrutiny, this intermediate scrutiny, the state doesn't actually have to prove in every instance that its lines are being drawn in the right place. Just generally, it's important to keep boys and girls separate based on sex differences and safety and competitive advantage. And so that's good enough under this intermediate scrutiny, because this is not strict scrutiny. This is not race. Now, if this was race, yes. Race, strict scrutiny, you've got to show every single instance there is a tie between what you're trying to do. Why would you be separating the races? and what are you trying to achieve by that? So in a race case, yeah, that would be super impossible to explain why segregating the races would be important in a certain event. The Supreme Court's only found that a prison race riot is the only circumstance that you could ever justify separating the races. If you had a race riot where the Hispanics and the blacks and the whites were all trying to kill each other because of their race, that's segregating them, may be a valid reason to do that. But that is a super extreme example. And here, there's nothing. You don't have to meet that level of scrutiny because sex discrimination is treated differently. We talk about separate but equal, and you sort of should shudder when you hear those words, because separate but equal in race is always bad, but separate but equal in sex is fine. It's fine with people use public bathrooms every day, and they understand that separate but equal is totally fine. But yeah, so that's why race and sex are treated differently. That's how they're treated differently.
Well, I'm reading from the opinion, and Justice Thomas concurrence, and says gender dysphoria is a mutable mental state that is the object of psychiatric treatment. It does not resemble the immutable characteristics on the basis of which our presidents have applied heightened scrutiny: race, sex, or national origin. Instead, gender dysphoria resembles other characteristics on the basis of which legislation may classify with merely a rational basis. And I love that he says, to use language to obscure reality, to show, quote, indifference regarding the truth, is to lie to the public and cease to treat our fellow citizens as equals. And I love that he said that. This is about truth, that we should not be lying. We should not say that boys can decide to be girls, that chromosomes can change at will, and that we shouldn't be force-feeding this indoctrination down the throats of our fellow citizens. It's wrong. So I mean, that's probably my favorite portion of the whole thing. I love that he said that.
Yeah, that's exactly the reason why we are so careful about race, is because it's immutable. You are born white or black or Hispanic. You don't have a choice in the matter, and you should be treated in a colorblind fashion. Your race should be a neutral factor, should not be a factor in anything, because that's just how you were born. This whole transgender movement, though, is about how you aren't born that way. You are choosing, you are gender fluid, you are decide to be queer, that you are changing your gender to align with what you think is your biological sex. All this is about mutable things that change, and that no one can be criticized if they say, well, today I'm a girl, but tomorrow I'm a boy. And that's like, you're supposed to be held up on a pedestal for making that change. You have changed your gender. And Thomas is saying here, yeah, that's a psychiatric condition. And we don't give people special constitutional protections because they have a psychiatric condition. We don't say that if someone has a mental disease or if they're an illegal immigrant or something, that their status is being caused by themselves or something else, and that it's not an immutable trait. It's something that changes. And so the government has leeway to deal with people who are like that. And they can make sort of rough rules, and they can say, these people are in and these people are out. Whenever the government makes a rule, it is classifying people. I mean, we classify people based on income. Certain people pay more income tax than others. Do we have to look at every single individual and say, well, is this income tax really fair for this particular person based on all of their personal history? No, we say the government's allowed to have some rough justice and make rough decisions when they're classifying people or businesses or or students or whatever, but like when it comes to race and sex, you can't. But this transgender stuff is like the opposite of all that. It's just sort of this fluid. It's in the definition. It's like a fluid, dynamic, changing situation that is not a permanent, immutable situation.
Cory, as a woman, I mean, are you happy with the court's language? I'm reading May Mailman, who's great. She says the court's language is better than I thought it would be. It states clearly boys aren't girls. I mean, it's hard to believe that we have to celebrate that, but we are. We're celebrating the fact that the U.S. Supreme Court has officially declared that boys cannot be girls just because they say, I feel like a girl. And I'm celebrating it. I think it's sad that that's the place we're at, but we're celebrating that. I mean, how does that make you feel? Were you expecting such strong language?
I don't know what I was expecting. I was thinking a lot about the legal decision and not necessarily about the language that they would use to provide it. But I will say, I also thought a lot about that. And I want your listeners to know, if they haven't read the opinion and the concurring and dissenting opinions themselves, the majority opinion uses the terms biological boys and biological girls. The opinion that's dissenting in part uses the term transgender girls and cisgender girls. And I mean, just as an initial matter, a lot of people are confused about those terms. They don't know exactly what they mean, and children are confused by those terms. And I agree with what you kind of read from Justice Thomas about it's not hateful to say what is true. Yes. And what is real. And it was very refreshing to see the court say boys and girls today. And I will say too, as a litigating attorney and someone who has read a lot of these cases, a lot of the appellate court decisions, man, we cannot agree on what terminology to use. Some court decisions say male and female. Other court decisions repeatedly, and briefs of the parties too, repeatedly use transgender girls, transgender boys, cisgender girls, cisgender boys. And it's not consistent. It's confusing. And I was very happy to see our highest court today use boys and girls.
Yes, it gets very confusing for you. Like if they say trans girls, I'm like, wait, that means a boy, right?
Yeah, even us, that we read this stuff all the time. We talk about it on podcasts and, things like that. You have to think for a second. I don't think it's wrong or bad or hateful to say boys and girls. Yeah. And I think we need to teach our kids what's true as well. And of course, that is not to be disrespectful. I always feel silly ever having to say that, but we're not trying to be disrespectful. We're saying what is true. And even the court kind of acknowledges this as well. And I lost the part of it that I had, but Justice Kavanaugh kind of addresses the fact about, well, what if this transgender individual, what if they've been on puberty blockers and hormones since a very young age, and now, the states are saying they're not banned from sports, they just can't play on the girls' team if they're male. They can play on the boys' team. And the other side might say, well, they've lost the competitive advantage. They didn't go through male puberty. They've been on these blockers and hormones. Well, the court says, yes, we sympathize with that. We want everyone to have the chance to play sports. It's a good thing to play sports, but Title IX doesn't guarantee a right to play sports. There are many students who try out and don't make the team, and that's too bad. But that doesn't guarantee a right on a team or a right to play a sport under federal law.
Yeah. And so Dan, you said that this could apply to even prisons, because that's another issue, because sex separation, the reasoning could reach the prison and the bathroom, locker room context. So how is that possible? Because that is another big issue, that when they're not separating, they're putting males who identify as females in prison cells with biological females, which is unsafe. But because they don't want to discriminate based on gender identity, they're doing this. Could the logic here be applied to cases even with prisons?
Yeah, the prison stuff is just mind-boggling, and even when I was at DOJ, 10 years ago and longer, we were putting men in female prisons. Even under the Walker administration, they were doing this, and they were all doing it because courts were requiring that. And courts were requiring men to be put in female prisons because basically the equal protection argument, the idea that, you have to have a very good reason to deny this transgender person access to the female space. That is their identity. They have a constitutional right to identify that way. This decision is really blowing a hole through that. First of all, the idea is that transgender status is not protected. They're basically saying that. They're restating Scrimeti. It's going to be a rational basis sort of situation. And second of all, distinctions based on biological sex are totally fine if they're sort of at least important. And I would say it is important to keep male prisoners away from biological female prisoners. There's a lot of important reasons to do that. And so I do think that this language today about why that sex separation is important in certain circumstances, especially in the area of safety, which is one of the two governmental interests they found to be important. Competitive advantage is one, and safety is the other one. So if safety is important to justify segregation, then it would seem to also apply in prisons and bathrooms, because there's pretty much two arguments in the bathroom context about why the government should separate bathrooms, male and female. One is safety. I think that's probably a pretty good one. And they say that you can use that as a reason. And then the other one is privacy. So privacy is the word that was not used in this opinion. And that's one thing we're going to want to add when we argue under equal protection. And we do have that in our new Richmond case. And under Title IX too, is that one of the interests of that a girl has, or a woman, in being in a segregated bathroom is an interest in privacy. And that privacy should be good enough to combat any claims that, hey, segregation is bad. But that remains to be seen, and we'll have to argue that in court. And we hope that privacy will be added as one of the reasons why you can keep segregation of boys, girls, men, and women in bathrooms.
And I'm reading right from the opinions. The states argue, and we agree, that the interests in safety and competitive fairness are important for the purposes of equal protection analysis, and the state's sex-based classification limiting women and girls sports to biological females is substantially related to those interests. Now, there's something I wanted explained. Here's a quote: "The states may treat all biological males the same and treat all biological females the same, given the inherent physical differences between biological males and biological females. In short, states are not required to conduct an individual by individual comparison of the physical and athletic capabilities of all biological males in order to satisfy intermediate scrutiny." So that's related to puberty blockers, right? That you don't have to prove anything.
Yeah, and that would be the same in sort of the prison context, is that the prisoner couldn't say, well, particularly me, the biological male, I'm not a threat to the women, and so you have to evaluate me. No, it's okay for the state to basically make rough judgments about large populations. Say, in general, men have a competitive advantage, and in general, men pose a safety risk to female, and that's good enough for this sort of constitutional inquiry.
So the burden isn't on you have to prove that you have some sort of advantage, like you show, like, hey, I that burden is not there. That's really important, because
Right.
that's an argument that we deal with a lot.
Well, I'll just add for context that is discussed in the dissent, and the dissent mentions that's what the West Virginia law used to be. The sex were sex separated, with exceptions, so not really. But children with gender identity could play on the opposite sex team if the school determined that fair competition would not be impacted by the student's participation. An opposing school could contest that participation by filing an appeal to the secondary school's athletic commission. And then there's a board that would assess whether allowing the student to play would affect the competitive equity or safety of teammates. So they had this whole process, and the majority seems to be saying that's not required by law. And they also, Justice Kavanaugh also discusses asking courts to do that on an individual by individual basis. Doesn't make a whole lot of sense.
Okay. Well, then I also want to talk, so talking about states like Wisconsin, where one of the big issues that I have been tackling and you have been tackling for quite some time, that we have a Seventh Circuit decision, and that impedes some of the progress that I think some school boards are trying to make when they are trying to draw distinctions. They're trying to eliminate policies that include gender identity and non-discrimination. How does this affect states like ours that are operating under some decisions that are problematic?
It's just a matter of time. It's our view those decisions are going to go away. It's just a matter of the Seventh Circuit is going to have to probably do it manually by itself, rather than having a district court judge sort of surmise that those decisions are undermined. But there is a case or two right now that is a vehicle where the Seventh Circuit can basically overrule the Whitaker decision.
Yes.
And I think the Martinsville decision are the two, right, Cory?
Yes, AC versus Martinsville is still ongoing. And there's one other case out of a school district here in Wisconsin that's ongoing. And I know, Scarlett, we discussed this on a previous podcast, so I won't get into the weeds when we had CC O'Leary on with us. But I just want to note, though, that the Seventh Circuit has arguably signaled a willingness to overrule those cases, because when the Scrimeti decision came down from the United States Supreme Court, the Seventh Circuit on its own vacated its own decision in the McWanago case, which is another one out of Wisconsin, and said, hey, parties, we want briefings, so we want you to submit written submissions to us about whether this case out of the United States Supreme Court, which, by the way, was heavily cited, maybe not heavily, but multiple times cited in today's opinion, does this Scrimeti decision mean that can Whitaker survive, and ask for briefing? And that case ended up, for procedural reasons, we didn't get a decision there. But the takeaway is that perhaps the Seventh Circuit has signaled a willingness to overrule Whitaker.
I want to talk about Scrimeti. It is referenced a lot in this decision. Can we discuss that just a little bit?
Yeah, I think here I want to pull it up because there's an entire block quote that Justice Kavanaugh pulls from Scrimeti. And they talk a little bit about, here, I'll get it up in front of me.
And what is, and to lay the framework briefly, what was that decision?
While you're looking at that, it's about Tennessee banned transgender medical treatment, put all those words in quote, for minors. And the U.S. government, the U.S. under President Biden, sued the Attorney General of Tennessee, whose name was Scrimeti, and said, you can't enforce that law. That violates the equal protection guarantees of the U.S. Constitution, because you're not allowing transgender kids to get the help they need. And the U.S. Supreme Court Scrimeti said, no, that's not a violation of the Constitution.
Yes, so it was a very similar analysis when it comes to the equal protection issue. And it is cited multiple times, but the part that came to mind for me is the court says, in closing on the equal protection issue, we repeat what the court said in Scrimeti. This case carries with it the weight of fierce scientific. Our role, and I think this is such a good line just in general with all of the commentary we're hearing about the court and its role, Our role is not to judge the wisdom, fairness, or logic of the law before us, but only to ensure that it does not violate the equal protection guarantee of the 14th Amendment. Having concluded that it does not, we leave question regarding its policy to the people, their elected representatives, and the democratic process. So I think they're kind of emphasizing the standard that they're applying there when it comes to the equal protection analysis. And, you know, we know that people are debating, well, do boys have an advantage or not? And what does all of this mean? And there's competing experts on each side. But the court was very clear today about the standard that it was applying and the reasoning for that decision. And I think they absolutely got it right.
Yeah. And I think that they are doing the job of a more conservative, traditional court. They are telling the people, you know, you want something, you're going to have to change it through the democratic process. And I think a lot of people were hoping, you know, compelling, you must. But I wasn't expecting that. And maybe because I talked to you all about it some, but I wasn't expecting that. I think this language was the most that I could hope for. I thought it was extremely definitive and strong. And now it gives people who want to change policies in the 23 states that don't have them, it gives them some of the tools in order to accomplish that, and then through the legal process. Now, we were talking about Whitaker before, and in my experience, a lot school boards, state legislators, they will say when talking about this, well, I'm open to changing my mind if we get a decision from the Supreme Court, you know. And so now we've got the decision. I wonder if they'll be open to changing their mind. I mean, how many school boards say, you know, we're sort of like the Emperor in Star Wars. We're only, this is temporary, and we'll get rid of this as soon as we hear something from the Supreme Court. Well, now they've heard something, and likely they may not make those changes unless what? Unless parents come forward, and unless, if they're not willing to follow the law, there's lawsuits.
Yeah, I will say, school board members, you have some work to do. Will is going to be putting out an explainer on the case, so you don't have to read the entire decision with legal citations. And we're going to be putting out a MOTA policy. We want to give you tools to empower you to serve in your roles. But it's going to take some work on the part of local school board members. And I personally, and I think Dan's with me on this too, I'm firmly on the side of taking action to protect girls' sports and girls' private spaces.
Yes. Dan, I wanted to talk about, in closing, I know we could keep talking about this, but you put on social media that mentioned that the court has agreed to take up another case, and it's not necessarily involving Title IX, but it's involving this issue with transgender, and it's pretty serious. So could you discuss?
Yes. So Washington State passed a law that said if a kid runs away from home, law enforcement is supposed to notify the parents, unless the runaway is transgender. Then you don't notify the parents. And if the runaway is transgender, you can do medical treatment on that transgender kid, and you don't have to get the parents have their knowledge or consent. So a group of parents sued and said, hey, we've got kids. They haven't run away, but we're sort of like the target of this law. So we want to sue. We think that's unconstitutional. It interferes with our right to direct the upbringing of our children, which we know was established in a bunch of cases that we've talked about, like Mahmoud. So all the courts, though, said, parents, go away. You don't have a right to sue. You don't have standing. You can't sue over this. Nothing's happened to you yet. Your child has not run away yet. You haven't lost your child yet, so you don't have standing. You haven't been harmed by this law. the Supreme Court decided to take that case, which is a strong signal that they're probably going to reverse. The case is called International Partners versus Ferguson. And what it's going to do is it's going to evaluate the standing rule that was put in place in that case called Mirabelli that we talked about a few months ago. So Mirabelli was an interim ruling on California's secret gender transition policy. California had a policy that said, hey, any school, you can trans whatever kid you want. You don't ever have to tell the parents. And the parents sued, and same thing. The court said, oh, you don't have standing. And the Supreme Court, in their opinion from a few months ago, said, no, actually, parents, in a very short line, said parents have standing to challenge policies that they are the object of. So the object of the policy in California was to keep parents in the dark. Therefore, parents could sue over that policy, the secret gender policy. So the question is, in this Ferguson case, are parents the object of this law to keep them in the dark about their runaway child? And the answer is probably yes. So this will give the court a decision to expand on Mirabelli and to explain how parents have rights to go to court to sue the government when the government tries to interfere with their right to direct the upbringing of their children, direct the religious instruction of their children, all those good things from the Mahmoud case. So this is a great case. And as we've talked about before, there are a lot of, this is a big issue we're going to be hearing a lot of. We filed 2 briefs with the Supreme Court asking them to take this case, and they did. The issues that are going to be presented, this issues about runaways and transgender runaways and laws that allow transgenders to run away and to support that, is going to be the focus of a lot of attention in the next several months, we'll say.
Wow. And I think if people listening think that there aren't policies that allow for staff members in a school to keep secrets about gender identity from parents, they are wrong. Just recently, we had discovered that in Dunn County, a pretty small area of Wisconsin, that their school board policies, I pulled them up, it was explicit in their non-discrimination policies. It said that if a student doesn't want their parent to know about a name change, different pronouns, gender identity, that the school was required to keep that secret. It was in black and white. These policies, they are everywhere. You may not be aware of them. Lots of times they'll sort of vote on them in batch. They'll just, once every school year, a school board will vote on new policies and supposedly updated with state and federal law, except for they never seem to be updated when things kind of go our way. But they'll vote, and suddenly there's this non-discrimination policy that no one's even read. They didn't know it was there, but there it is. And a situation arises, and a parent wonders, how could you keep secrets? Well, they'll say, we were just following board policy.
Yeah, there are many parents out there that are suffering in silence. So this is primarily an issue with middle school aged girls and freshman, sophomore age girls who are sucked into this world of transgenderism that is supported by the administration and the guidance counselors, and this basically encouraging kids to tell the authorities that they're going to kill themselves or their parents hurt them at home, and that if they just say magic words, they'll be able to run away and they'll be able to stay at a place away from their parents. They'll be able to stay at a safe house. And these stories are being told all around the country, and there's lots. You can Google these and see all the summaries from 5 or 6 different states. There's been major cases about this already. But I think there's a lot of parents that don't know, because sometimes these are also caught up in maybe divorce proceedings. And so it gets kind of murky about who has custody and this and that, and maybe the child's sort of manipulating the parents. But the idea that the government is facilitating runaways who are transgender is real. and it's going to be exposed. And I think the problem goes much deeper than people would care to admit. It's very scary for parents.
Last year there was a Moms for Liberty town hall in Colorado where 3 parents that had suffered that exact scenario spoke. It was heartbreaking. I could not believe what I was hearing. In one instance, the child, a middle school girl in 7th grade, not only was removed from custody of her mom, she was placed into custody with the teacher that had started the GSA club that radicalized her. So
Yeah.
the mom lost custody and the kid was living with one of the kid's teachers. And it was called the Glitter family. It was a affirming family, and taken away from the non-affirming mother who loved her daughter very much and just simply did not believe that her daughter was a boy. That's it. And it's crazy.
I was thinking the same thing that you just said, is that it's heartbreaking because if a child is struggling with that, I mean, let's be honest, it's not a fun thing to be going through. And especially if you're a girl, like, you want your mom. Like, having my own mom and now having kids, like, it's a special relationship. Even if you're not getting along, even if you're butting heads, even if you say you hate your mom for whatever reason, that's your mom and you're going through something hard. And to have a system that's pulling you away from that is truly heartbreaking. And from a legal perspective, an egregious violation of parental rights.
Yes. And we talked how this is happening in middle school. Well, it's no wonder, because this is the girls and the boys, they are hitting puberty. It's confusing time, hormones are raging. And I think that especially kids that are suffering some other underlying conditions, the most vulnerable, they are susceptible to this. It's not going to be the captain of the football team that's susceptible to this. It's going to be kids that are vulnerable. And that's what makes it very insidious, is this ideology really, really attracts kids who are suffering, and it's disrupting families. And it's really wrong. It's really wrong.
Yeah, we'll keep you updated. We'll have something to announce pretty soon, hopefully sometime this summer. And when we do, we'll let you know, and we'll be able to talk about this a lot more in detail.
Well, I look forward to hearing from that. So in closing, I want each of you to talk about because we always a call to action. What can parents do? Now we've heard this ruling. We've been waiting for this ruling for a long time. There's a lot of good things. It's not a magic wand that's going to suddenly, erase all of the issues. There's still a long road ahead. But what's the best outcome of this decision, and what should parents do next if they're concerned about their daughter, if they're concerned about their kids, or if they're currently going through something and they are suffering in silence and they don't know what to do?
Yeah, it's a big question. I mean, the number one thing I think just in general is for people to be more involved in their school board, adopt these policies that we have on sex separation and parents' rights, the stuff that's on our website, and they're already written out. It can just be adopted by a school board. And these are super popular policies that are like 80-20 issues. Like, boys and girls should have separate bathrooms. Parents should have notice of controversial subjects that are being taught to their kids. Parents should have the right to opt out. Kids shouldn't be secretly trans at school. These are like 80-90% things that you can put in your school board and say, like, you guys need to adopt them. And guess what? If somebody is refusing to adopt these policies, you should run against them. In Wisconsin, every April we have school board elections. So we've got to keep getting candidates to run against these school board members who are stopping this parents' rights revolution that's going on right now.
Yeah.
So that's number one. Number two is that individually, if you're having trouble with the school, you feel free to reach out to places like Will that we can provide resources. Ask in writing to opt out of things. Ask in writing to have notice of things. Assert your rights as a parent. The burden is on you. You are the parent. You have to raise your child. You have a lot of responsibilities, and we just can't blame the school district when you could be asserting your rights. You could be communicating with the teachers and the principals and the guidance counselors and letting them know what is interfering with sort of maybe your religious instruction at home, what's interfering with your family values, what you want notice of and what you want to opt out of. You've got to be proactive and can't just sit back and say, well, I'm a victim of the system. So we can't be victims of the system. We have to go out and assert our rights.
Yes, 100%.
Yeah, I don't have a whole lot to add. I just wanted to clarify that the Supreme Court has now done its job by clarifying what Title IX allows. So it's up to states, it's up to school boards, administrators, parents to make sure that those protections are reflected in either your state law or your local policy. So like Dan said, get involved, ask questions, reach out to an organization like Will, if you have questions or you want to take a look at our policies or our explainers. We want to help and empower you. But I mean, this is a big decision today. This is the biggest Title IX decision maybe in decades. It's a great win for girls, for female athletes, and there's more to do.
Yeah, there's a lot more to do. And so if you are a school board member or you are a parent that is trying to urge your school board to remove gender identity from the language that's their non-discrimination language, Title IX protections in your school district, you should use this case and you look to the documents that you're going to provide. Sort of, when will that be released, do you think?
We're looking to put it out this week. Hopefully we'll get it out, turned around really soon. But I agree totally with what you said. And I just want parents to get involved and, keep doing the work and protecting girls.
And now is the time, because a lot of times, like I said, it'll be July and August where school boards will meet and they will adopt new policies based on changes in state and federal law. So this is the time to do it. This is the time to look over your board docs and to look at your policies and to feel confident that you can protect women and girls, that you can define sex to be male and female, that you don't have to be bullied anymore, and that you can do the right thing. And it's going to be now the onus is upon you to do the work. So do the work.
Specifically, if the district legal counsel or administrator, school board members, whatever, if they say, oh, well, we need to have gender identity we could lose our federal funding under Title IX. That's the type of thing in particular that this will help you respond to.
Yes, 100%. Well, thank you guys for coming on and going through all of this. I'm sure there'll be more questions, and I'm looking forward to hearing more about what's happening regarding the secrets that are being kept from parents, expansions on Mirabelli. But I'm happy with this decision. It seemed like this time last year we were discussing Mahmoud v. Taylor, and now we're discussing this. So thankful that the court is bringing common sense back. And I mean, this is just common sense stuff. So thank you for going through this with us, as always, and thank you for all that you do for parents and kids in Wisconsin. And thank you.
You're welcome. Thank you.
Thank you too.
Thank you, guys. All right. And everyone, I am going to run this again. We're going to replay this stream, and it's on our YouTube. So if you please share it, there's a lot of details here. You might want to listen to it again and take notes. But there's a lot of good legal points here, and I highly advise you to use it. And please If you would like to learn more about Will, go to, I should put that in the comments, but where should they go to access all of these resources? I think I have it.
WILL-law.org.
And I think I should have it here somewhere, but I'm going to put that up. Here we go. I got it. There you go.
And Dan and I will be sharing them on X as well. And you can just find us under our names.
Yes, so please go here, and there are a ton of resources for you to access model policies that can be applicable to states other than Wisconsin, and just a lot of, you have videos, resources. We look at them all the time. Even our national team watches these videos all the time. So thank you so much for all that you do, and thank you, Will. We really appreciate you. All right, have a happy 4th of July to both of you.
Yep, you
Yes.
too.
Have fun with your families and your
America
kids.
250. Yes.
Yeah, America 250. Yes, have fun decompressing and not thinking about gender identity for a little while. Just a little bit. All right, bye guys. That was a wonderful discussion. So many good points were made. Probably what I want to close with is one of the biggest that the Supreme Court ruled 6-3 that states can keep boys from competing in girls' sports. 23 states still allow boys to compete in girls' sports. However, there is language there. There's language that says states and school boards can prohibit biological boys from playing in biological girls' sports. So if you're a state that does not currently protect girls' sports, maybe your school board still can. So there's going to be a lot, this decision just came out, and a lot of constitutional law attorneys, especially public interest firms like Wisconsin Institute for Law and Liberty, like Kim in Southeastern Legal Foundation, who we talked to earlier, like Alliance Defending Freedom, like America First. There are so many, Thomas More Society. They are going to be really digging in, and there's going to be a lot of challenges in the 23 states. So no one should lose hope. Everyone should celebrate today. It is sad. It's sad that we're celebrating the fact that the Supreme Court had to say that boys can't decide to become girls, and that we cannot pretend, and we cannot be forced to pretend otherwise. So the truth matters, biology matters, and reality matters. And so, yes, I'm going to celebrate. I'm going to celebrate this Supreme Court decision. I'm going to celebrate especially Kavanaugh's opinion, where he really details what it's like to be a female athlete and why this matters to female athletes. And I'm going to tell you that I know in this discussion, we talked about the fact that people say, well, there's not that many. There was a comment that said I could only find 10 cases where a biological male was competing and robbing girls of their medals and opportunities. First of all, there's more than that. But second of all, 10 is 10 too many. 1 is 1 too many. It's bigger than just the 1 or the 10 too. This is all about accepting this non-reality and conforming our speech, conforming our science, pretending that I have comments in here that I'm not following science. I mean, get real. XXXY, that's it. And if you even try, I talked to a biologist this weekend, the whole intersex thing, like that is a non-issue. The way that they describe it, they're not talking to this biologist, who I am going to interview and bring on. She's great. She's going to explain this in depth about how ridiculous it is when she hears these non-science arguments by so-called scientists, that she's like, they're just trying to keep their job. they've just been brainwashed. They know, she's a professor, biologist. She talks to these people behind the scenes. She's like, they know. They're just going along because it's easier. And unfortunately, really bad things happen, and they continue to happen when people lack courage and they do things that are easy instead of standing up for the thing that's hard. Now, I think it's getting easier and easier to stand for truth, but there are certain areas where it is not easy. There are certain, I think even I could say in California, it's hard. Well, having just been to California and meeting all of these wonderful people there, there are millions of Californians that think all of this is ridiculous. It's just they don't have control of the levers of power, largely because of the voting that happens in California and the sort of the weird way that happens. But there's a huge population in California, and a big chunk of that population agrees with us. It's just they have been robbed of institutional power. And so that's a whole nother topic. But the path to recovery starts with this. Right now, it started with the grassroots action and states that even the states that started to put these kinds of protections on the books when it was much harder. 27 states have put the protections on the books. That's great. Now, those 27 states are protected from legal challenges from radical groups like the ACLU. That's great. The definition of Title IX, that's great. Because now the court has said it. And like Kim Herman said, well, Congress could pass, they could pass a law that defines and protects women and girls sports. Welcome that. Defines sex under the definition of Title IX to be male and female. That's great. But the courts have basically done that. It's done. They have defined sex to be male and female, and that protections under Title IX are afforded to females, and that gender identity is not covered under the Equal Protection Clause, and that suffering from gender dysphoria is a mental condition that would be treated by the medical field and that is not an immutable characteristic. It's not an immutable characteristic that is afforded protections under the Equal Protection Clause. That needs to be, if you are fighting this battle in your school district, if you've got crazy people that are trying to tell you that something wrong is something right, that a boy can decide to be a girl, that a girl can decide to be a boy, these are not true things. They need your prayers, they need your sympathy, but you are not required to be kind and nice to them in such a way that you're going to allow your daughters to go into the bathroom with them. Okay, that's not kindness, that's insanity. Do not let your daughters go into a bathroom with a male. If you have half of a brain, you know that you shouldn't do that. But like I've said, there are those with their brain, like they're so open-minded, their brains are literally falling out. And you don't want to follow people like that. You don't need to listen to people like that. Truth still matters. Truth counts. And now you've got the Supreme Court. You can say, hey, the Supreme Court even says it. Biological reality matters. It's just a really, really big deal what happened today. And I think there are some that live in states that have, like I was talking to my friend Marcia, where in Illinois they've codified these certain protections, these non-discrimination. But as we've heard our attorneys tell us today, it's not definitive, but the language of this decision, now known as BPJ, it's a culmination of Hecox v. Little and BPJ versus West Virginia, there's language that says school districts can ban boys from participating in female athletics. And I'd say that on the issue of safety, that you can ban boys from private spaces because gender identity under federal law is not covered by the Equal Protection Clause. You have got a case that it should not be treated as such in your board policy. Your board policy should not be lumping in gender identity with sex and race when discussing non-discrimination policies and policies that generally fall under Title IX. Yet, school district after school district, they blindly have passed these packets. You know, they don't read what they're voting on, kind of like in Congress, and they pass things. And they're told, well, you have to do this because it's the federal law. No, it's not federal law. And in Wisconsin, it's not state law either. So there's the purple states. There are purple states where it's not state law and it's definitely not federal law, but you've got a Democrat governor and you've got Republicans that control the state Senate or state assembly. So you're at a bypass. Nothing quite is getting done. Well, there's a solution to that as well. There's elections coming up and you can vote for candidates that stand for truth, and you can make sure that that is the issue that you are voting on. And if a candidate is standing for truth and they are vowing to interpret Title IX the way that the Supreme Court does, that there are protections for male, female, protection for girls, that sex is defined as male and female, then that's who you vote for. And if they win, then you too can be living in a state that has protections. So, and that's what the Supreme Court, I think they rightly said. I know that there's some that wishes that they had said they must, but they are kicking this back to the states because this is the traditional court, a more conservative court, that they're not trying to be an activist court. And I think that's something that we want. There are some decisions you like, some that you don't. But at the end of the day, I think when you look at the full body, especially this week of all the decisions released, it'd be difficult to say that this is a court that is right wing and completely mega, because they've made decisions, some that the president supports, some that the president does not support. They are making decisions based on their interpretation of the role of the Supreme Court, which is to be a check, not an activist. This is not supposed to be the activist branch of government. And that is something I have long held believed. And I know it's hard. It's hard because we want solutions. We look at the way the left operates and thinks they'll do anything. They'll do absolutely anything to win. And we need to do what it takes to win. But I would argue not anything. And so I am happy with the SCOTUS decision. I think it's very strong. I think that the language could not be stronger in support for female sports remaining female, girls sports for girls. And I think that we have a lot to celebrate. And as we go into celebrating 4th of July and 250 years of freedom and liberty in America, I think we should take a break from all of this for a little bit, enjoy time with our families, and then, after that, start gearing up and getting ready to do what needs to be done at the state and local level, do what needs to be done so that if you are in a state that does not have protections, that you become a state that does have protections. If you have a school district that is not protecting your daughters, that you become a school district that is protecting your daughters, and that's going to be through school board policy, and you're going to want to get really involved in, if your state has elections for the head of your state Department of Education, you're going to want to really get involved in that. So in closing, let me see, I wanted to read some of my favorite passages. It's been a very long day for me. Let's read one. To provide equal opportunity for female athletes, schools do not merely maintain, for example, one soccer team, one basketball team, one ice hockey team, one lacrosse team that are equally open to male and female athletes. That approach would deny equal opportunity to female athletes because, as all agree, females and males have inherent physical differences relevant to athletic performance. That is in the opinion, and 100% right, 100% right. I think we could end this whole thing right here. The term sex in the 1972 Title IX statute, the 1974 Javits Amendment, and the 1975 Title IX regulations cannot plausibly be interpreted to refer to anything other than biological sex. The ordinary meaning of the term sex at the time of enactment in the early 1970s was biological sex and not gender identity, particularly in the sports context. That is a direct quote, Sex means biological sex. It means male and female. Gender identity are not protected class. If you suffer from gender dysphoria and you think that you are a male, that is, you are not covered as a protected class under the Equal Protection Clause. And you are not afforded rights plus. That is not something that is offered to you. And this is a truth that needs to be shared so that these kids do not operate under false illusions. And their parents aren't either. And so that decisions can be made. And so don't drop out. If you're a boy claiming to be a girl now, don't drop out of the boys' athletics. You need to stay there. That's where you're going to need to compete if you would like to continue to participate in athletics. You're going to need to stay on the boys' athletic team, dressed like a girl. If that's what you choose to do, fine, do it. But you're going to be doing it with boys. Girls are not going to have to pretend with you anymore. Girls should not have to pretend that woman face is actually a woman. That's just not fair. It's not right, and it's not real. So if you're a boy and you're an athlete, prepare to stay on the boys' team. That's where you belong. You can continue to participate, but you're going to do so not on a girls' team. You're not going to make them uncomfortable. You're not going to take their trophies. You're not going to take their athletic scholarships. You're not going to do a long jump and start dancing around like a pretty girl. Like, that's not okay. You're going to have to do all of that on the boys' side and see how that works. But you're not going to do it with girls. And you're not going to go into girls' spaces, and we're not going to put tampon machines in the bathrooms of elementary school boys. We're not going to do that because boys don't menstruate. And we're not going to pretend that they do. We're not going to pretend that men get pregnant because they don't. They can never do that. They cannot do it. They don't have the equipment. They don't have the uterus. They don't have the ovaries. They don't have cervix. They don't have any of that. So a man can never get pregnant, and that's never going to happen. So that's the reality. So we're going to just we're going to speak the truth, and it's okay to do that. It is not against the law to do that. Nothing can compel you to say that a lie is true. You have free speech rights, and you should feel free to exercise them. And then you should make sure that you are teaching your kids to exercise them, and they should be watching you, learning from you, and getting courage from you. Maybe, and even if your kid says, "Oh, that's embarrassing," well, too bad. The kids get embarrassed by lots of things. Kids get embarrassed if you start singing out loud in the car, or if you start dancing to a song that you like. Especially teenagers, they get embarrassed by everything. But deep down, they are more grounded when they watch their parents stand for reality. And if they watch their parents cave, they'll cave. And they're not going to have a whole lot of respect for you. So be the example for your kids. After this case, something is also very, very clear, that we need more parents, and we need more girls to stand up and be counted, to tell their story. In that vein, I also have something that will be revealed shortly, but I've just spoken to a family, and there's going to be a big story that we're going to start to roll out. We're going to tell this story of a brave girl and her family, and what happened to her when she was forced to compete against a biological male and in a blue state. And I just talked to a parent today and asked, what was your opinion of this decision? And the response was sad that it has come to this, sad that I'm happy when the Supreme Court finally validated everything that my daughter has been feeling, validated the fact that she felt uncomfortable competing against a male. She didn't want to. They didn't even know that it was happening. They weren't warned ahead of time. And that she was unprotected, and that when the truth came out, that she was ridiculed, received death threats, bullied, but tortured, basically tortured for the truth. But she's ready to speak out, and so is her family. And this is a story that we're going to tell. And I think there are a lot more stories like this. So getting back to when I was talking to Dan and Cory, you don't hear a lot about these athletes. Even in California, I was talking to some parents. There are a lot more of these male athletes competing in female athletics. A lot of times, maybe they're not winning, so no one says anything. They're not winning yet. Or the girls the girls and the families, they don't want to lose their athletic scholarships. They don't want to get the death threats. Parents don't want to lose their job. Girls are afraid of what other people say to them. Lots of reasons, but there are many more cases of boys competing in girls' athletics than you have heard. You should go to a website, He Cheated. I think it's hecheated.org. You'll see a lot of statistics there, but that doesn't even cover it, because there are so many. I will tell you, in my state of Wisconsin, I have had many very credible complaints, but they're not, they complain, they tell me about it, they're not willing to come forward. Understandably, I'm not going to judge or force anyone to go through some of what Ella has to go through. It's not an easy thing, especially for a kid, but there's a lot of love too. There's a lot of love and support. So when you do come forward, I will tell you, you will not feel alone. You will feel so much less alone than you do by staying silent. instead of constantly being bombarded with hate, you may still get some of that, but then you're going to get double doses of love and encouragement and support from the people that are listening right now, to my followers, to members of groups like Moms for Liberty, politicians that support you, they have your back, leaders that support you and have your back. There's so much you're missing when you're not coming forward. You're missing the camaraderie, the support. Jennifer Say will tell you this. A lot of the girls that she mentors will tell you this, that coming forward, being vocal was the best thing they ever did. It changed the trajectory of their life forever. And once you survive, once you're a survivor, once you survive what happens when you come up and stand for truth, you now have this like Teflon skin, because now there's nothing anyone can say that will make you live a lie. And you've just, I mean, you've got that feeling that you can't even put into words, when you know that you have courage, when you have been tried and tested. I say this all the time. While very difficult, particularly early on, my journey, my own personal journey, oh my gosh, a lot of bad things happened to me, a lot of trials and tribulation, a lot. And I can tell you, I don't regret any of it. I regret nothing, because it has made me the person I am today, and has given me the best gift of all, which is the I don't give a crap attitude that I have towards the woke crazy people who don't like me. And I don't like them very much either. So we're even. And they're trying to end my way of life, destroy my civilization, rob me of my children, brainwash my children against me and against this country. So you know what? If this isn't my hill to die on, I don't know what is. And if it's not your hill, I don't know what ever will be. Because if something's coming after your kids and your daughters, and that's not the hill for you, then you don't have a hill. Jennifer Say said that, and it's true. You don't have a hill. So you need to rethink your priorities if fighting for your children against this woke nonsense is not important to you. And don't think I'm going to homeschool my kids, it won't get to me. It will. So homeschooling parents, you have kids in private school, this is still your fight. This is still your community, still your tax dollars being spent. And all of this trickles down. It will affect your life. These are the kids in your community, the kids that your kids are going to be friends with, they're going to date, they're going to be in community with. It matters. And you cannot bury your head in the sand and think, well, I'm not of this world. If you're a Christian, no, like I'm looking to my heavenly home. Well, I must have missed that part in the Bible that said, mind your own business, the parable that Jesus told to all of his followers. Hey, mind your own business. I think I remember the part where he said, anyone who harms a child, better off tying a millstone around his neck and throwing himself in the river. That is how precious children are. So if you're a Christian and you are going to deny the imperative that you must protect the children, that is your job as a Christian to protect children. If you're going to be in denial of that, then you really need to reconsider your priorities and question, are you really following the path that God wants you to follow? It is your job as a Christian to protect children, your children, the children around you, like protect them. Do everything that you can to protect them. And even if it means you have to sacrifice, you have to make that horrible sacrifice that people you've never met online are going to say bad things about you. This too shall pass. You'll get over it. There's probably a ton of comments under there. And you know what? I don't care. This is me not caring what these people think, because why should I? Most of them don't even have their name attached to their stupid comments. And there's a couple, there's one that's making a lot of comments who works in the New Richmond School District, a paid employee of the New Richmond School District. She likes to harass the kids that refuse to use the pronouns and refuse to say that a boy can become a girl, a bully. Do you want, I mean, are we the kind of people that cave to bullies? I was just minding my own business. That's nowhere in the history books. I didn't have the time. That's nowhere in the history books. I don't feel comfortable. That's not in history books. This isn't my place. That's not anywhere in the history books. No one remembers people who don't stand up and say, "Here am I, send me." They don't remember those people. They are forgotten for a reason. History remembers the brave. Your children will remember. Your community will remember. So be brave. Be brave in the way that you can. Do what you can. You don't have to be on camera like I am. You don't have to run for office, but maybe you are the person who can run for office. Or maybe you're the person that can support the person running for office. You can join Moms for Liberty. You could be a leader of Moms for Liberty. You could be a member. You could be a person that's out front. You could be a person that's helping behind the scenes. There's always something you can do. There's no excuse to not stand up, to not do something. And we are here reading this decision because there were brave parents that stood up, brave kids that stood up, pro bono law firms that took these cases, very smart legal minds that work for far less than what they could make were they in the private sector. They take the pay cuts because they believe in the cause of liberty and freedom and truth and justice, and they're fighting for it. So with all of these people that are willing to do so much, I think it's incumbent upon all of us to do our part as well. And so go forth, do something. Don't just say something, do something. Be that person. We're celebrating 250 years, 250 years. Be the change maker. I wrote, let me see, bring it up. I wrote a really good speech for an event that got rescheduled. And the speech was, and I'm looking right now because it was a little long, but the speech was right here. Stay in the fight. And the theme, lead. And it's really good. I'm gonna when I do give it, I'm gonna record it so you can hear it because it's really good. I spent a lot of time writing it because it was something I felt really that God laid on my heart to write, but I'll read just this last part. So the next time that little voice tells you you're too small, too tired, too outnumbered to matter, you look at the kids like Ella Frei, Riley Gaines, Paula Scanlon. There's so many kids, Maddie, Alexa Anderson, Peyton Manning. And many, the girls on the West Virginia shot put team. I believe one of the little girls' name is Adelaide. I just listened to her mom's story told on the Sage Steele show, and it had me in tears. Little girl, 7th grade, 8th grade, and what she had to endure. You should listen to that because the mother telling story, there's a story behind, you see BPJ, there's a story behind that. At West Virginia, there are girls that were sexually harassed and taunted by this boy who made lewd sexual suggestions to them, terrified them, and then beat them at the sport that they loved and trained for. This opinion is more, it's not just a legal opinion. There are little girls and there are their families that are behind all of this. If it wasn't for those families and the girls speaking up, we would not have this decision today. Their courage is going to protect so many. Their courage has set precedent. Their courage has now once and for all defined sex under Title IX. Their courage has made it possible for the Supreme Court to say unequivocally that gender identity is not a protected class under the Equal Protection Clause. All of these things because brave little girls, 7th and 8th grade, said no. And the parents said no. Do what you will to us. We are going to fight this so no other little girl has to go through something like this ever again. So that boy pretending to be a girl, not a victim, according to allegations, not a victim, actually the opposite. So know the facts. Kindness. Who should you show your kindness for? How about for the girls? Empathy. Who should you be empathetic towards? Maybe the girls that are getting harassed and sexually assaulted and teased and tortured. Who should you have concern for? Maybe the girls that don't want to use a bathroom with a boy. Maybe a girl who, when she's menstruating, doesn't want to know that there's a boy next to her in the stall as she's using the bathroom. Maybe it's a girl who doesn't want to pretend that boys can get pregnant too. Who should we protect? Maybe girls that are on a volleyball team that are being forced to play against a boy and they're worried that they're going to have the ball spiked into their face and suffer a brain injury too. And even you take out the risk of physical injury, let's just say in track, the girls that have to lose opportunities, the girls that have to suffer the humiliation rituals of standing next to a biological male and smiling and pretending that this is all just fine. There's no neutral mountain left to hide on. The woke have made sure of that. They're playing for keeps. So you should too. Get off the couch, get off the pew, get off the hunting stand. Put down the phone, put down the remote. Turn off the computer and get in the fight. Stay in the fight. Get others in the fight, preserving our communities, our state, our country, our civilization, our way of life. Lead, not because you've got all the answers, not because you're the bravest one in the room, but because somebody has to be the vessel who says out loud with meaning, "Here am I, Lord, send me. I'm the one. I'm the one I've been waiting for. There's no one else. It's me." It's not send somebody else to save me or save someone else. Send somebody else, Lord. It's send me. I'm the one. Be the one. Be the hero. Be the person that you've been waiting for, that others have been waiting for. If you do that, you will not regret it. If you do that, you will be a change maker. If you do that, you will make a difference and your life will be changed. You will only ever have as much tyranny as you're willing to kneel to. Let me say, you will only ever have as much tyranny as you're willing to kneel to. You need to say, these knees don't kneel to anyone but God. You don't kneel. You stay in the fight. Stay in the fight, and God bless you. Now, let's roll. It's time to go out and save this country. So, happy 250th birthday, America, land of the free, home of the brave, land of liberty, land that I love, land and country that is worth all the sacrifices. Because I want to leave my children a country that is free. I want to leave them a better place than what I had. You know, it's unfortunate that looking back at the 90s, like this golden era, the 80s, the 90s, that can be recaptured. And it is. There's so much good. Don't be black-pilled all the time either. There's a lot of good things. If you're feeling a little down, go to Freedom 250 and America 250, but follow Freedom 250. And look at the joy and happiness. And if you are in the DC area, go to the Great American State Fair. It's really great. And there are, having just come from DC, every Smithsonian has some new exhibits, so patriotic. There's a bunch of new things. So if you haven't been there recently, you're going to be surprised. The museum underneath the Lincoln Monument is open. For years now, there's been construction in front of the Supreme Court, in front of a lot of the iconic monuments. That's down. You can enjoy them. They look beautiful. It's very, very safe. I walk around at night all the time. I feel perfectly safe. There are police on bicycles. You see a lot of there's always, you know, I feel perfectly safe. And around certain areas, you see like some of the National Guard there, and it's not at all intimidating. It's not at all scary. It's great. It's wonderful. So I highly encourage you to go there and experience this once in a lifetime event. 250 years. There's a lot of things going on between now and August. And in your community, there's a lot of great 250 events. So check out what's happening in your community. Go to your community parade. Take your kids, take your grandkids. Again, put down the phone, turn off the TV, shut down the computer, and enjoy America. Enjoy it. Have some fun. Have some laughs. Eat a lot of food. And then, you know, as healthy as you can. But I know we're all maha, but you can take a little break, have some fun, have some snacks, but enjoy your life. A lot of people sacrificed. They gave their life for you to have this wonderful experience with your family. They gave all. Now, you don't waste the gift that they gave you by complaining all the time. And stop and let's not constantly judge. And like, oh, I would have done it this way, or he's the lead, you know, things aren't happening fast enough. I think let's have some grace, and let's be thankful that we have a president that loves America. We have a cabinet that truly loves America, and you've got so many good things happening and a lot of bad things that aren't happening. Sometimes we need to be grateful for the things that aren't happening because of the administration that we have in place right now. There's a lot of bad things that aren't happening, a lot of bad things that are being prevented, and there's a lot of good on the horizon. So have hope, be optimistic. Happy 250th. Enjoy the time with your family. I still have some podcasts that'll be airing through the week. But I am certainly going to be enjoying time with my family, and attending some parades in my community, and just enjoying the blessings of liberty. So you should too. Happy 4th, happy 250th America. Good night, everybody.
It's amazing to actually read the words written, with the Supreme Court pen, like affirming everything that we knew was true, and rejecting their challenges on every